Hi, comrades and friends, viewers KVS. Today I want to discuss with all of you about the contributory negligence, which is a very, very important one so far the postal employees are concerned. Under the nature of penalties, one of the punishment is recovery from the pay for the loss sustained to the government. The recovery of loss sustained to the department is being recovered from the officials by issuing charge sheet under the contributory factor. So the contributory factor is a major problem so far our postal employees are concerned. Suppose if an official defrauds the government money, or some SAS agent or someone who are defrauding the government money, the amount which could not be recovered from the concerned culprit or the main offender, the entire amount is being recovered from the subsidiary offenders under the contributory negligence factor for the flimsy reasons for not adhering to rules to prevent such frauds and losses. This is happening everywhere. Prior to that, you should understand how to safeguard our official. That is very important so far the contributory negligence factor is concerned. As per Rule 11A of the CCS rules, if an official is not directly responsible, no recovery can be imposed on any officials. So naturally, that means an official should have nexus or who should contribute to the fraud, and if he is not directly responsible, no recovery can be imposed against him. This is the main protection available under the CCS rules 11 within bracket 3. That is very important. And the government, it can recover the amount from the subsidiary offenders either as a whole or a part of, or any amount as they can fix for the contribution they made to the loss. As per Rule 106, that is of the volume 3, penalty of recovery can be imposed only after establishing a particular act or negligence which is a reason for the loss sustained to the department. So this is a major protection for us. So Rule 106 of volume 3, as per the orders, the role and the responsibility of the official should be established. If it is not established, no recovery can be imposed against the officials concerned. As per Rule 107, then the same volume 3, before imposing punishment, the gravity of the case, everything has to be weighed in a proper manner, and thereafter only the punishment can be, the recovery can be imposed against the officials. Actually, the disciplinary authority should assess the matter properly, and thereafter only he can make recovery against the officials. So these Rule 11 within bracket 3 of the CCS rules, Rule number 106 of volume 3, Rule number 107 of volume 3, these three are very, very important. Very, very important that we should be very thorough about it. And also, it is obligatory on the part of the government that if the loss sustained to the department could not be recovered from the main culprit, thereafter only the recovery can be imposed from the others under the contributory factor, for which a charge sheet should be issued containing the lapses of the concerned officials which led to the loss to the government of India. That is very important. But what is going on? Generally, the officers did not evince any interest to recover the loss from the main culprit or main offender. Immediately after detecting a fraud, what he should do? He should immediately confiscate the property, whatever he is possessing or his family is possessing. The property should be immediately confiscated, and where they should not allow the culprit to either sell or transfer the property to some other name. It should be guarded, safeguarded. And actually, what is going on today? Simply for the small shortcomings, they are immediately proceeding against the innocents. This is going on in the department. Instead of taking immediate action against the main offender, they are simply let off, and days are going on, and subsequently after a lapse of 2 years or 3 years, for making the recovery of the loss sustained to the department, they are spreading over all the entire amount, and it is being recovered under the contributory factors from the innocent and gullible officials. If the recovery could not be made from the offender only, this recovery can be affected. But this is not practically prevailing in any other divisions or any other circle. Only by mentioning the shortcomings of the officials or misinterpretation of some rulings, the recovery is being made. And also, at the time of giving the first statement, in most of the cases, our officials are giving the confession statement. Yes, I made these under the pressure and I forgot and I have not checked properly, all these things without verifying the records. Suppose if an SB withdrawal is under the charge sheet, instead of verifying the SB7 in original, yesterday I have told you that you can verify the originals also. You have to verify the original, and thereafter you have to check whether you have worked on the day by checking with nominal roll and the attendance rolls, and also if there is any arrears, any backlog, that also to be taken note of. Only after that only you have to give the statement. But what is the present situation? When the officers are asking, immediately you are giving a confession statement, and by taking the confession statement, they are compelling to credit the loss sustained to the department. This is going on. And sometimes some misplaced sympathy. We are thinking that the government will consider us favorably. So as per the dictates of the officers, we can give and come out from the cases. That is also the thinking of certain officials, which is a misplaced grace we are expecting, which is not practically possible, and finally it will be a problem to the officials. So always giving the confession statement is also a major factor, and that we should take note of very seriously. And generally what we are seeing, immediately we are saying, due to very extraordinary work prevailing on the particular day, this was unnoticed. I am sorry, I am praying excuse, and this is the first time, I may please be excused. Like that only, whenever the officers are demanding statement, we are giving the statement. That we should not give such a statement without verifying all these things. It is very important. And the court, either CAT or High Court, they have given so many verdicts in favor of the employees. They have very categorical judgments are there. Unless the official is directly responsible to the loss sustained to the government, no recovery can be imposed. There are many court judgments are there. All those judgments and the content should also be properly placed while giving the statement or while giving the reply. And particularly when they are saying that you are violating rule number so and so, before giving statement, you should check whether the ruling you mentioned is correct and whether there is any mistake committed by the concerned. Everything to be checked before giving the statement. If admitted the omissions at the initially, and finally whatever you are saying, they will simply say that you are at fault or you are at something. So that is also not advisable. There is no guarantee. So you have to protect yourself by giving the statement properly at the time. This is the normal process we are making. But in many cases, after getting the show cause notice, our people are crediting the amount. Our people are voluntarily crediting the amount in order to avoid any proceedings further. And secondly, most of the charge sheets are issued at the verge of the retirement. When the people are about to retire, immediately some charge sheet issued, and they are frightened whether they will go, they are going to get the retirement benefits or not. Immediately they are forced to credit the amount. This is also happening at field level. Most of the cases, they have been taken up by the department at the verge of the retirement, and the punishments are imposed in most of the cases. And when they want to proceed, they will issue only Rule 16 memos. Actually, there is a difference between Rule 16 and Rule 14. Rule 16 means it is a minor penalty. That we are going to discuss separately about the disciplinary rules, in which I will categorically mention what are all the difference between both. But if it is Rule 16, it should not affect the pension. Whatever be the punishment, that should be over before the superannuation of the officials. But Rule 14 is different. When they are issuing a Rule 16 charge sheet, it should be completed before the retirement. If it is not completed before the retirement, it will become void. But suppose if it is here Rule 14, and if the enquiry is not over, if the proceedings is not over before the superannuation, it will be converted into Rule 9 of the CCS pension rules. So there is a difference. So even though they have already categorized, the rules they have categorized, what are all the cases are to be brought under the Rule 14, and what are all the cases to be given under the Rule 16, because ours is a quasi-judicial, and whatever be the punishment they are going to impose, that they will decide much earlier. Much earlier they were deciding. At the time of issuing a charge sheet, they are weighing what kind of punishment has to be given. So 80% of the statements nowadays the officials are giving that it is due to heavy work and also the extenuating circumstances. Extenuating circumstances means that when a PA is working with double-handed, or there is a pressure across the counter. So these are all the mistakes committed that should be excused. That is called the extenuating factors or extenuating circumstances. And more than 80% of the representations we are giving to the department praying for excuses by considering the extenuating circumstances. How to safeguard? That is very important. How to safeguard our official? Whenever the officers are asking you to give some statement, you should not immediately give the statement. One person is having every right to verify all the records before giving statement. After giving the statement, you can get the copy of the same also. You are having the right to get a copy of the statement, whatever you are giving, because that is a prima facie statement. That is going to be more vital document till the finalization of the case. So, when you are giving a statement, you should obtain a copy of the statement from the concerned officers. So, before giving statement, you should yourself verify whether you have worked on the particular day, whether the mistake was committed by you, or is there any other circumstances, whether rule mentioned everything are correct, everything you have to check. So you cannot immediately give the statement. Such a cases, you can have consultation with the knowledgeable person of your division or the persons nominated by your circle union, so that you can have discussion and you can know how you can come out from the case at the future stage. That is very important. And also, I have already told, if you are giving to refuse statement, the department cannot action on the very same day. But if you are protracting to give the statement, the department can proceed against you. That's why I told. Even yesterday, Sorup Gandhi asked me, from Asansol asked me, is it not violation of rules? No. The first time, when you are saying first time, I could not give the statement on the day itself, I will give the statement after 2 days, 3 days, that nobody can question. But if you are telling that I will not give statement and you are protracting, then it will be a subversive of discipline. That will be brought under the conduct rules thereafter. But at the initial stage, you can ask time, for which you can get it, definitely. So, at the time of giving statement, you should be more cautious. And as per the law, nobody can be testified to give statement against their vote on the very same day itself. And it is my request to everyone, before giving statement, you should have a thorough study of the case, thorough study of your responsibility and your role, and thereafter only you have to give your statement. This we have to protect. What are all the precautions you have to make? First, you should know whether you have worked on the particular day. And also peruse the document. What are all the documents? While perusing the documents, you can very well understand whether you have committed mistake or not. Thereafter, you can check the rules. And you can check the rules, and to the extent of your knowledge, you can check the rule. And also, if need be, you can have consultation with the knowledgeable team. And also, my request is, never trust the officers. Don't write the dictations of any officers, and don't expect any mercy from such officers. This is my request, because many times the administration is giving false assurance, and resultantly the officials become a scapegoat at a later stage. This I am seeing in many things. After given the statement, don't fail to get a copy of the statement, and you can keep it. Because if tomorrow Rule 16 is given and the contents of the Rule 16 is differ from your prima facie statement or something else, and also at the time of inquiry, if it is a Rule 14, if your defense assistants know the situation and everything, your copy of the statement is very much required. These are all the generally precautions you have to make, and all the other things. So, comrades, what are all the contributory negligences, other factors, and how all these things comes, everything we will discuss in the next chapter. Because if it is a lengthy chapter, people are being frustrated and not seeing the channels regularly. That's why I want to give in parts instead of a whole. I want to give it in a parts, and the rest of the part will be discussed in the next episode. Thanking you, yours KVS.